What you know, Alibiers. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. It's Monday, March 10th. Hope you guys had a good weekend. We're going to read the state's motion in limine regarding the text messages and testimony of roommates DM and BF. These text messages took place during the time or shortly after Ethan, Xana, Kaylee, and Maddie were killed. These are newly unsealed, and we're starting to get a little better look at the chaos and the confusion between the text messages and the 911 call, which we went over this weekend. Let's read through this filing. The state is asking to admit the text messages between DM and BF on November 12, 2022, and testimony from them regarding their conversations with each other on November 13th, 2022. The phone records were discovered on the hard drive of DM's iPhone extraction provided on April 5th, 2023, and State's Exhibit 18 from the grand jury record. The testimony of DM and BF were provided to the defense as part of the grand jury record. Just a heads up, that grand jury record is still sealed, so we don't really know the contents of that. The first section is the standard of admissibility. We went over these same standards of admissibility with the 911 call, but let's go through them again. In general, testimony that is hearsay is excludable at trial. That's Idaho Rules of Evidence 802. However, there are exceptions to this rule. Two firmly rooted exceptions are Idaho Rules of Evidence 803-1, and that is present sense impression. A statement describing or explaining an event or condition made while or immediately after the declarant perceived it. And Idaho Rules of Evidence 803-2, which is excited utterance, a statement relating to a startling event or condition made while the declarant was under the stress of excitement that it caused. The requirements of the federal version of the present sense impression and excited utterance are best stated in U.S. versus Mitchell. There are three principal requirements which must be met before hearsay evidence may be admitted as a present sense impression. 1, the declarant must have personally perceived the event described. 2, the declaration must be an explanation or description of the event rather than a narration. And 3, the declaration and the event described must be contemporaneous. The requirements for hearsay statements to constitute an excited utterance are 1, a startling occasion, 2, a statement relating to the circumstances of the startling occasion, 3, a declarant who appears to have had opportunity to observe personally the events, and 4, a statement made before there's been time to reflect and fabricate. They cite some case law and say both exceptions require the declarant personally perceives the event or condition about which the statement is made. In addition, both have temporal limitations which limit admissibility. Under the present sense impression exception, the declaration must be substantially contemporaneous with the event in question. The fundamental premise underlying the present sense impression exception is that substantial contemporaneity of event and minimizes unreliability due to the declarant's defective recollection or conscious fabrication. In U.S. versus Green, courts have given broader temporal limitations for excited utterances. In U.S. versus Napier, the U.S. Court of Appeals held, although in most cases, the startling events which prompt spontaneous exclamations are accidents, assault, and the like, there's no reason to restrict the exception to those situations. They give an example, victims' statements, he killed me, after being shown a photograph approximately 8 weeks after the attack was held admissible. Following Napier, some courts have admitted excited utterances made well after the event when the declarant was suddenly subjected to rekindled excitement, because events may so deeply traumatize a person that long after stress has subsided, a chance reminder may have enormous psychological impact, cause renewed stress and excitement, and utterances relating to the original trauma. And they cite Matter versus Troy P. There's no requirement within the language of Idaho rules of evidence that the declarant be excited or emotionally affected by the event or condition in order to fall within the present sense exception. But if so, then the statement can overlap with the excited utterance exception. And they cite U.S. versus Jones, holding that statements were admissible under present sense impression and excited utterance exceptions to the hearsay rule. The next section is the argument. DM's phone record for November 13th, 2022, and BF's testimony as to what DM told her should be allowed at trial. Starting on November 13th, 2022 at 2:10, DM sends a text to EG, an Uber driver, to inquire if he's driving. The state submits this text message exchange is not hearsay because it will not be offered for the truth of the matter asserted, which is the Uber driver's status. Instead, it would be offered to show a timeline for the night that DM was awake and texting at 2:10 a.m. From 4:19 a.m. and 7 seconds to 4:21 and 50 seconds, DM attempts to call Xana, Kaylee, and Maddie, and all calls were unanswered. The records of these calls are not hearsay as they each do not meet the definition of a statement. Oral assertion, written assertion, or nonverbal conduct intended as an assertion under Idaho Rules of Evidence 201A. From 4:22 and 8 seconds to 4:24 and 27 seconds a.m., DM and BF send the following text messages. DM to BF. No one is answering. I'm really confused right now. DM to Kaylee. Kaylee, what's going on? BF to DM. Yeah, dude, WTF. Xana was wearing all black. DM to BF. I'm freaking out right now. No, it's like a ski mask almost. BF to DM. Shut the F up. Actually, DM to BF. Like he had something over his head and little ND mouth. I'm not kidding. I'm so freaked out. BF to DM. So am I. DM to BF. My phone is going to die. And then the F word. BF to DM. Come to my room. Run. Down here. All of the above declarations are present sense impressions and excited utterances. This is supported by DM's grand jury testimony where she indicates she just witnessed a startling event, which is heard noises in residence and saw an unknown male in the residence. The declarations indicate both BF and DM are trying to make sense of the startling event. No time for reflection or fabrication. See DM's grand jury testimony attached. That's not public. It is still under seal. At 4:24 and 39 seconds, DM calls Ethan, which was unanswered. At 4:24 and 50 seconds, BF texts DM. I'm scared though. And BF responds at 4:25 and 16 seconds. Yeah, I know, but it's better than being alone. At 4:27 and 47 seconds, DM calls Kaylee, no answer. And at 4:28 and 44 seconds, DM calls Xana, and it's unanswered. At 4:32 and 57 seconds, DM texts Kaylee saying, please answer. The next morning, DM sends the following text message starting at 10:23 and 23 seconds. DM to Kaylee, please answer. DM to Maddie, are you up? She also texts Kaylee, are you up? DM's text from the night prior and reflect her then perception of what was then occurring, waking up, realizing she hadn't heard from her roommates. At 11:39 and 9 seconds, DM has a text exchange with her father. These won't be admitted for the truth of the matter, but as a timeline for the morning. At 11:50 and 55 seconds, DM receives a text from Jay stating, bro. At 11:50 and 58 seconds, DM calls EA, which is not a statement. At 11:51 and 1 second, DM receives a text from Jay. 1:04 and 1 second, DM receives a vandal alert. These won't be admitted for the truth of the matter asserted, but instead to show a timeline for the morning. The state anticipates both DM and BF will testify at trial. The state intends to ask each witness about statements made to them on November 13th, 2022. This testimony should replicate the testimony they provided at the grand jury proceedings. The state submits the statements from DM and BF to each other are allowable hearsay because they are present sense impressions and or excited utterances. Judge previously ruled the text and statements of DM to BF are present sense impressions and excited utterances and exceptions to the hearsay rule. And they summarize this saying why this should come in, and that is pretty much the end of the filing. We will see what else comes out this week. As you guys know, the judge was concerned with the lack of transparency regarding the filings in this case, and we've seen a little flurry of things released last week. Maybe we'll get some more this week, and if we do, I will be here recapping it for you. Hope you guys have a good rest of your afternoon, and we will see you soon.